Thank you. Thank you. First of all, let me just tell you how delighted I'm to be here, although remotely, but still together with you. Thank you very much for the kind invitation. The topic I'm going to talk about is remote hearings, procedural background, and practical pitfalls. Roughly a year ago, probably remote hearings or the remote hearing of certain witnesses or experts was an unusual occasion, and usually when something went wrong. So when, for instance, a witness or an expert had a medical condition, or when an expert couldn't fit the hearing into the schedule. And that has, of course, changed with the COVID-19 pandemic. And I guess we've all had some practical experiences with online hearings in the meantime. I'm going to look at three aspects of remote hearings. First of all, are they, or to what extent are they procedurally permissible and under which conditions? Secondly, what are practical experiences? What can be improved with remote hearings? And the third question, I think they have all been already addressed in to some extent by the previous speakers, is will they stay or will we return to our previous practice once the COVID-19 pandemic is gone? And I come to the first question: are remote hearings procedurally permissible? And of course, I think there will be few who doubt that in the current situation. But still, if you look at the practice of courts and arbitral institutions, there have been some objections and they have to be taken seriously. First of all, the question is, does the law at the seat of the arbitration allow remote hearings? Do the arbitration rules allow that? And what are the implications for enforcement? First of all, the seat, the lex arbitri, governs the procedure, and most laws, to the extent I know, don't specifically regulate remote hearings. So you would normally have a provision that says the parties, unless they agree to have not to have a hearing, have a right to have their case heard orally. The question is, does that mean a physical hearing, or is a remote hearing also an oral hearing? And in the past, prior to COVID-19, there have been some commentators, and especially from the German-speaking region, who have said that the principle of immediacy of the hearing, so the immediate impression the arbitrators should get from the witnesses would speak against the permissibility of remote hearings. And that these voices have become silent, I think, after the outbreak of the pandemic. But still, they were there in literature, and I have seen a number of parties making such objections in arbitrations. Now, the Austrian Supreme Court, and that is just by way of example, there are lots of other decisions, but the Austrian Supreme Court has had the occasion to render a well-reasoned and very extensive decision, which I think can be applied to lots of other jurisdictions. First of all, the court said that video conferencing technology is not only used in arbitration, but is also widely used in the practice of courts, at least in Austria, including in criminal proceedings. Secondly, the court said during the COVID-19 pandemic, having remote hearings was basically the only way you could have a hearing. And online hearings were also no violation of Article 6 of the European Convention on Human Rights. because there was not only to have a right to have an oral hearing and to present one's case extensively, but also a right of the claimant to have the claim heard and decided within a reasonable time. So the court very robustly and in quite strong words affirmed the permissibility of remote hearings in arbitration. Now, as to the question, when is it appropriate to have remote hearings? And of course, we are all now under the impression of the pandemic, but the question is how we will deal with remote oral hearings after the end of the pandemic. And here there are, in my opinion, four main criteria to be taken into account. First of all, the reason for a remote hearing, and of course, the pandemic is a very good reason to have the hearing remotely. But there may be also other reasons, and the carbon footprint is, in my opinion, a very good reason also to have a hearing online. The second question to be answered is what should be the content of the hearing? Is it a procedural meeting? Is it a hearing that deals primarily with legal or jurisdictional aspects, or is it a hearing dealing primarily with witnesses and experts? The next is how do remote and physical hearings compare? If you have, for instance, all of the participants or most of the participants located in Austria and within very short distances, and the time impact is probably not too critical, then that would speak in favor of probably postponing the hearing. On the other hand, if the witnesses and other participants are located all over the world, if the time impact would be critical, then of course that would militate in favor of a remote hearing. And finally, there is the issue of equal treatment, the technical possibilities of all the participants to have an online hearing. And in that context, I have often heard that parties or witnesses are lacking adequate equipment. However, if you look at the costs of a hearing and just the travel costs of the participants, and if you look what the costs you have to invest into proper technical equipment would be, then very often I would submit that the technical equipment, the cost of technical equipment are much lower than the travel costs and the other costs of a hearing. So that usually would not speak against the remote hearing in my view. Yeah, these are the technical or the legal, general legal aspects underlying remote hearings. I come now to the practical aspects, and all what I'm going to say is not rocket science. Yeah, we all know it, and much of it is common sense. However, in the hearings that I have seen, a lot of this could have been improved and could have improved the experience and the outcome of the hearings a lot. First of all, again, the equipment. It's remarkable how often a hearing is disrupted by inadequate audio and visual equipment. And as I said, the costs of this should not be a factor. Even for one single hearing, the costs of equipment are probably lower than the travel costs of the participants of a physical hearing. Secondly, the possibility to have efficient document production or the efficient showing of documents during the hearing especially during the examination. All that is available on the platforms that are used. However, somebody needs to take care that this is really done efficiently in advance. It is very useful for arbitrators to have private rooms for deliberations and also for parties. Again, the technical availability is not the problem here. It's rather the training of the participants. So I have seen, unfortunately, arbitrators who were not aware when they were in private rooms and when not, so that parties could overhear in part their deliberations. Of course, everybody tried to notify them as soon as possible. It is, in my opinion, essential to have immediate technical assistance available. So if there's a technical problem, there is a quick solution. The costs of the technical assistance are much lower than the costs of having a delay of a couple of hours to the hearing. There is the issue of data security and confidentiality. There need to be adequate protections that nobody may enter the hearing room who is not permitted to the hearing. Again, that comes with the technical assistance. Usually, unless arbitrators are very tech savvy, it's better to have somebody professional check that. And finally, I've seen hearing platforms not work, so it's always good to have a second backup platform available. Now, as to the practical aspects, what is important? What are some practical takeaways after a little bit less than a year of online hearings? First of all, it seems trivial, but the hearing etiquette is still something that can be vastly improved. I've seen lots of hearings that were disturbed by people who were not muting their phone, their computers when they're not speaking. There were all sorts of online hearing fails, like for instance, people who did not turn off their video even in the breaks, microphones that were not muted, and obviously private statements could be heard by everyone. So that is something that people really need to be aware of. The second is the timetable. My experience is that it's not possible to have the same hearing days as you would in a physical hearing. So my personal experience is that you can have a maximum of probably 6 hours that you can really concentrate, and afterwards the attention usually gets lost. Internet problems are still probably the single most important cause for interruptions. So either at the end of the arbitrators, but usually at the end of witnesses, internet problems do disturb hearings. And I would really think that prior to having bigger hearings, it's worthwhile to invest in an upgrade and a check of the internet connections so as to avoid any problems. And there are some general considerations of equal treatment and procedural fairness. And by that, I mean practical issues, such as, for instance, you have one party that is located in a country with good internet and with adequate online hearing facilities, and another party that does not have so easy access to that. That is, in my opinion, not a principled reason why we should not have remote hearings, but the arbitrators need to be mindful that it may take some time for one party to upgrade their equipment, to do the tests, and probably to to get some external advice on how to conduct remote hearings. And that needs time and needs to be taken into account in the timetable. Another issue that was already mentioned is things like time zones. Yeah, if the witness, and I've seen that, if the witness has to get up at 4 o'clock in the morning for his or her examination, then that's probably not very fair to the witness when all the other participants are in another time zone. So I think apart from the affirmation of the possibility in most or almost all cases to have online hearings, arbitrators need to have need to be very mindful of the procedural fairness in practice. And I come now to the final conclusion. Is it here to stay? Will we have in 1 or 2 years' time after the COVID-19 pandemic is over, will we still have remote hearings, and how will we have those hearings? I think we all agree, and I think all the previous speakers agreed that the previous practice of physical hearings will not stay. Remote hearings are a viable alternative for hearings in many cases. However, we also need to be mindful of the fact that online hearing or remote hearings are not the same thing as a physical hearing. So we need to be careful when remote hearings make sense and in which circumstances they make sense. Certainly, I think it's also having in mind the carbon footprint. Organizational hearings, organizational discussions, pre-hearing conferences and the like don't need to be made physically unless all the participants are in the same city. The same is, I think, true for jurisdictional hearings and hearings that are devoted primarily to legal argument. I think also simply having in mind the time that may be saved with remote hearings, emergency arbitrator proceedings and expedited proceedings will likely, in my opinion, also be held with remote hearings unless there are very exceptional reasons that speak against them. The question is, will we have remote hearings for a witness and expert hearing that is scheduled to take place over 3 or 2 weeks time? I don't want to be, I don't want to sound conservative on this. I think that is one of the things where I still have my doubts. Yeah, we do like to see ourselves personally. I think that's the human nature. We do want to, although I don't think that the examination of witnesses in an online hearing is of a lesser quality than a physical hearing. I do think, after all, the people will just like to see each other personally rather than see each other online. So I think, yes, there will be a change. The change will be significant. I don't think that physical hearings will go away completely.